Hi, thank you for joining our webinar. My name is Jessie Peterson. I am the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible William Porter, a California construction lien law guru. Today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I would like to introduce the fabulous William Porter.
Wow, thanks, Jesse. What a nice introduction. I wish I got that in my normal human life other than being online. Thank you very much. So let's talk about what happens after you record the lien, because um, uh, there are certain deadlines that have to be followed, certain tasks that have to be taken care of, and if you fail to do any of these things, you're going to lose your mechanics lien. So let's go on to there's some legal disclaimers and things of this type, a little bit about me, but the first thing you need to know is that there is a mechanics lien lawsuit deadline. This is the most important thing that you need to do. Is once you have your recorded mechanics lien, you have to look at the date in the upper right of the mechanics lien. There's going to be a date when the mechanics lien was recorded at your county recorder's office in the county where the property you worked on is located. Look at that date, and then you have to calendar forward 90 days. Now, 90 days is the 90th day is the day by which you must file a lawsuit. Otherwise, your lien is going to expire. Okay, it is mentioned here on this slide here. It's a prerequisite. You can see on this slide, if you want to look up the details on this, you can look up California Civil Code 8460, and it'll give you the details. But this 90-day deadline is important. Now, there will be other claims which are going to be part of the lawsuit. Of course, you're going to have a breach of contract, because if you didn't get paid, that undoubtedly breached a contract. But you're probably also going to have claims like, let's say there's a payment bond. Okay, and you might be able to be paid for that. So that will be part of your lawsuit too. These kind of claims are called causes of action, like breach of contract is a cause of action. Foreclosure of mechanics lien is a cause of action. On your a payment bond claim that might be out there that you make a claim on, that's going to be a cause of action. You might also have a stop payment notice. Let's say you're a subcontractor or a supplier. You're entitled most likely to a stop payment notice, which is going to stop money from coming from a lender or the owner to the prime contractor so that you can get paid from that money. And then there are other causes of action, open book account stated. I mention these in the context of the 90 days because these other claims, like breach of contract, payment bond, stop payment notice, they all have deadlines for filing a lawsuit also. But I'll say this, the shortest deadline for filing a lawsuit on all these claims is the mechanics lien lawsuit deadline, which is 90 days. So if you pay attention to that deadline, then you should be okay on all of these other claims, because you'll be calendaring things based on the shortest deadline. It's also important, as is noted on this, in the bottom of the second paragraph here, is that you can't call your attorney the day before a lawsuit has to be filed and say, hey, I got this lawsuit, it has to be filed tomorrow, because it takes time for your attorney to pull together the documents and information that they need in order to file the lawsuit. So you probably, in addition to calendaring out 90 days for the lawsuit itself, give at least 2 or 3 weeks a lead time to your attorney. So call them during 2 or 3 weeks before the lawsuit deadline and let them know everything you can about the fact that you have this dispute, you have a lawsuit deadline, it's in what the 90th day will be, and then give them all the information they need. Now, at the same time, here's something really important that you have to do between the time you record the mechanics lien and you file the lawsuit. It is common that people will file a mechanics lien and then not go forward with the lawsuit. So the owner, many times, and I will advise owners of this, why don't you wait and see, I'll say to them, and see what happens. See if someone is going to miss their 90-day deadline, because you know what? If they miss their 90-day deadline, barring a rare exception I'll discuss, then they've missed their opportunity to have a claim against you and your property. So what you need to do is you got to get a hold of whoever owes you the money. maybe that's the owner, maybe that's a general contractor, maybe that's a subcontractor, and say, hey, listen, by the way, I am well aware that I have to file a lawsuit within 90 days. So I want you to know that I'm not going to miss the deadline. So you can dispense with that notion right now. What I would like to do is talk to you and see if we can resolve this. Because you know what? I am owed the money, and here's your argument. I am owed the money, and I will have the property sold if I don't get paid. And in the end, all that's going to happen is that you're going to pay me the money that I am owed. You're going to pay for your attorney. You're also going to pay for my attorney. Okay? You're going to pay for both attorneys. Why do you want to do this? Why don't we get this resolved and leave the attorneys out of the picture and get this done? And then see if you can get it resolved. And if you get it resolved and the check arrives for the money that you're owed and the check clears the bank, be cautious of things that can be reversed. To tell you the truth, even cashier's checks and wire transfers, they can all be reversed if it's done quickly enough. Usually the person will truthfully or untruthfully say, oh, I'm a victim of fraud. And then the bank will reverse either the wire transfer or they will cancel the cashier's check. So just be sure that you get the money in your account irreversibly, and then you should be fine. And then if you get paid, you can release the lawsuit. Here's some things I should give you caution to note. If you willfully inflate your mechanics lien, then what's going to happen after that is if someone can prove that, then the penalty for overinflating your mechanics lien willfully is that you lose the entire mechanics lien. They don't adjust it down to the proper number. You just lose the entire thing. So before you file a lawsuit in that 90 days, you want to make sure that did any other checks come in? Is the lien right? Because you can always reduce the lien and get it to the proper number. So just be advised. You don't want to lose the lien because you have inflated it. Just keep that in mind. The amount of your lien, by the way, should be the principal amount that you're owed. On that number, you're not going to be adding in, let's say, interest and attorney fees. There is a little spot on the lien form for putting in interest, but it's in addition to the main figure, okay? So that's going to be purely what you're owed on that figure. There are classes that SunRay does on recording your lien too, and I've done those, and that's another course that you can take, or if you wanted to, you could call my office if you needed some help. And just say, hey, I listened to you at a SunRay seminar online, and I have a question. Can you help me out? And I'm sure I'll be able to help you. Now, when the lawsuit is filed, it's important, and you need to tell your attorney. If you use an attorney that is an attorney that deals with lawsuits involving mechanics liens, stop notice, and bond claims, that type of thing, they're already going to know this. But within 20 days after the lawsuit is filed, your attorney also has to record at the county recorder's office a notice of pendency of action. And so when you talk to your attorney, you might want to remind them, oh, please be sure to file a notice of pendency of action, because if they don't, then the owner might be able to sell the property free and clear of your lien because you didn't do this. So what we do in our office is that as soon as we file the lawsuit, immediately that day or the next day, we will put together the notice of pendency of action. We'll send it over to the county recorder's office and get that recorded. Basically, what it is, it says, hey, by the way, world out there, anybody who could look at the county recorder's records, which is anybody, our lien did not expire. Instead, we filed a lawsuit on it. So that'll keep it from being sold. If it is sold, it'll be sold including your mechanics lien as part of the sale. Okay, so that's the notice of pendency of action. Okay, now there is a way to extend the lawsuit deadline beyond the 90 days. It's a notice of credit. Okay, there's a document, I think, for this purpose on our website. I will say this about it, is that usually if you extend the lawsuit deadline, which you have to do with something that is going to have to be signed by the owner, signed before a notary, and then recorded at the county recorder's office as the notice of credit, you got to go through all that trouble. Then all that usually happens later on is that it just extends the inevitable, and then sometimes someone will file a bankruptcy. Mostly it is a way for people to try to figure out how to get out of the obligation to pay you. So I don't usually recommend a notice of credit unless there's a very reliable reason that if you wait a little bit longer, you'll get paid. And that's usually not the case, but it is a possibility, okay? So consider that there is a way to extend that lawsuit deadline, but I don't usually recommend it. But I wanted to be complete on the issue, so I thought I'd put in this slide on the notice of credit. And at the bottom there's the code section that you can look at to do this. But again, I don't recommend it. You might as well get it going, because you know what? Actually, after you file the lawsuit, the other side has 30, 60, 90 days to respond. Technically, it's 30. But that date can be extended very informally without recording anything or doing anything about it in most cases. And that gives you another further opportunity to work things out before the other side has to file a responsive pleading in court. So there's still plenty of time to get these things resolved. Okay, but I wanted to tell you about the notice of credit. And then if you do get paid, as I mentioned earlier, and the payment clears the bank, then be sure to release the mechanics lien once you're paid. If you don't release the mechanics lien, as is noted on this slide, then what could happen is that the person who has a lien on their property would go to court, and a judge would release the mechanics lien, and then they would put a judgment against you, the lien claimant, for not releasing the lien when you've been paid. You not only do you have to release it when you've been paid, but you also have to release it if you missed the 90-day deadline. Okay, I know people like to say, oh, the guy didn't pay me, I'm going to leave this as a thorn in his side. If you do that, there's a remedy for them, and they just go to court and have a judge release it because it's expired or it's been paid on. And what will happen is that the judge will put a judgment against you. And then it gets worse after that, because someone could take that judgment, and if you're licensed with the CSLB, they'll send that judgment to the CSLB, and the CSLB will suspend your contractor's license until you pay. So that's not good for your business, because if you work on a suspended contractor's license, you're subject to something called disgorgement, which is very bad for you. And it's another subject you can look up. If you want to Google it, I've got articles out there on the internet. Just look up California contractor disgorgement. And then even you can say Porter, and you'll see my article, or I think I may have two of them. Anyway, you got to release that lien if you get paid or if you miss the 90 days. Otherwise, you're going to have bigger problems. All right. I thought I might mention about the relation back effect of mechanics liens. This is really important. All the mechanics liens will relate back to when someone first began working on the project, not just you, but anybody. So this is important when you're going to get paid. Let's say you have to sell the property in a mechanics lien foreclosure, and there's a deed of trust. Well, who gets paid first? The deed of trust, which is the bank, which is usually a large amount of money, or your mechanics lien, which is probably much smaller, or many people's mechanics liens. The rule is this: is that all the mechanics liens relate back in their priority to when some person first started working on the project. Not you, anybody, like maybe the guy that dug the trench for some foundation wall. So this often is an issue when a deed of trust is recorded. We had a case, as an example, it was in Stockton, okay, recent, and they were building a large hotel. And we had all these mechanics liens for people who weren't paid. We then looked up when the deed of trust was recorded, and we were able to go to an earlier contractor on the project and determine that that contractor started work 4 days before the deed of trust was recorded by the bank for the loan on the property for all the work that was to be done to build a hotel. And once we were able to prove that that work started before the deed of trust recorded, then the rule is this: all the mechanics liens are required to be paid first before the bank gets any money at all on the deed of trust. So it's nice that liens all relate back to when someone on the project first started doing work. Okay, I thought I might mention that because that comes up and that's wonderful. And then you win over the bank that has the deed of trust. Okay, now there are, when you have a lawsuit on a mechanics lien, you are also, and I'm going to go through this really quickly because in the interest of time, you are also going to have probably, hopefully, a stop payment notice, which is a notice that you would have sent earlier on around the time you did your mechanics lien, and you can talk to your attorney about this, but it stops the money from flowing to the GC or from the owner to the GC or from a bank to the GC, so that you will have a source of money to get paid from. And the stop payment notice is a little bit longer for the lawsuit. You have to wait 10 days before you file the lawsuit after you do the stop payment notice. But then you have to file the lawsuit no later than 90 days following the expiration of the period within which stop notices must be served, which is kind of confusing. So, but there in the second paragraph here on this page, you can see that the lawsuit deadline is going to be either 180 days from the day the project was completed or 120 days from the day of a valid notice of completion or notice of cessation being recorded. Okay, so if you look at this deadline, it's accurate, but the one for the mechanics lien is purely 90 days. It never gets to be like 180 or 120, it's 90. So as I noted at the bottom here, if you use the 90-day deadline of the lien, you're never going to miss a stop payment notice lawsuit deadline, or, and I'll turn the page, and it's the same thing here. Call your attorney a few weeks before, but the lawsuit deadline for stop payment notice is longer than the mechanics lien, and so is the payment bond claim lawsuit deadline. So I will mention on the payment bond lawsuit deadline, it can be very long. As noted on this page, if there is a payment bond and it's recorded, then you have to file a lawsuit within 6 months after completion of the work of improvement. Now that's if the payment bond is recorded. Sometimes people discover about the payment bond later, and maybe they do or they don't have a mechanics lien or stop payment notice right or claim at all, and they go, oh, I can go after the payment bond. So if it's recorded, you have 6 months to file a lawsuit. But if it's not recorded, your lawsuit can be up to 4 years later. Now, you don't want to wait 4 years, but you want to do it as soon as you can. But there is hope for you if you miss out on the mechanics lien or the stop payment notice lawsuit deadline. I would just move it, even though you have these long time periods. If you do have a payment bond claim out there, then calendar 90 days, and you won't miss that deadline, and you won't miss the one for the mechanics lien, stop payment notice, or the payment bond. And of course, again, be sure to get a hold of your attorney a few weeks ahead of time. And if you do get paid and the check clears the bank, then of course you have to do a release of stop payment notice, a release of payment bond claim, and or release of mechanics lien as soon as the payment clears the bank. Irrevocably clears the bank, I should add to that phrase. Let me see if I have anything more. Oh, no, there we are, and now we're up to questions. And so, Jesse, I'll turn it back over to you.
Well, first of all, thank you so much, William. That was a wonderful webinar. You had a lot of really great information for us. As for questions, I do not see any questions at this time. However, if anyone does think of a question, please feel free to reach out to myself or to William, and we will be sure to answer any questions. Can you go to the next slide for me, please?
Okay. Oh, there we go.
All right, please take a moment to review us on Google. We would really appreciate that.
Thanks, everybody. Listen, if you have any questions, please be sure to give me a call.
All right, can you go to the last slide for me, please, William? Thank you.
And
that is all that is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you guys at our next webinar. Again, thank you, William. You were incredible, and I hope you all have a sunny day.
Thanks, Jesse. Thanks, everyone, for attending. Bye-bye.
Bye-bye.